hello everybody. Hello, welcome. Hello, good to see you. So working on my setup here a little bit, trying to make sure I'm able to see everything okay. So welcome in. Hello, good to see you. Good to see you. I'm feeling better. I'm still not 100%, but I'm definitely better. Doing better. One day I'll be 100% again, I'm sure. I think a lot of people have been struggling recently. So, yes, good evening. Hello, welcome in. Welcome in, everybody. Usually I have my sub chat only on Sundays, but tonight I am trying to kind of catch up a little bit because I have been sick. So I do have my comments on here while we do the first part of the live tonight. So, common cold lasted almost a month. Oh my gosh, Kimber. Oh, I'm so sorry to hear that. Yeah, it's just yikes. Don't overdo it. Oh, for sure. I've got to be pretty careful. I don't want to go back. I don't want to go backwards. No thanks. Nope. But welcome in, everyone. Welcome in. I am a little bit disorganized, but here we go. Let me get my calendar out. I think that's the best way to start. Here we go. Hi, hello there. Hello. Yes, so typically my lives are 7 o'clock Central, and usually the days of the week that I go live will depend. This week will be looking like, yes, I am feeling better. Thanks, Blue, for asking. I will be doing a live this week. Let's see, I think we'll probably do Monday, Wednesday, Friday this week. Monday, Wednesday, Friday. But sometimes I do an extra bonus one if something very exciting is going on. So I may need to hop on, if we have new news. So, but I will probably do Monday, Wednesday, Friday this week, the best that I can. And that's always a soft schedule. So if I have to cancel, I usually will leave that in one of my stories, everyone. So if you're interested, or if you're wondering, of course, you can always message me if you're wondering when my next live will be. So feel free to do that. I do have my DMs on, and I have so far no problem with that. So, but this week's live should be Monday, Wednesday, Friday. Of course, today is a special situation because we have typically my sub chat Sundays, but today I've left comments open for everybody because I have been absent the last few days. So I wanted to catch everybody up on what's going on. So welcome in, everybody. Yes, good to see you. So just to give you a little forecast into what is going to be going on this week, everyone, oh, my cats are playing, so I apologize. So we have in the New York criminal case, the deadline for Mr. Trump to plead his defense for advice of counsel is due on Monday. We have the Blessing Game status conference on Tuesday. Now that is, yes, happy Sunday to you as well. The Blessing Game case is the civil case out of D.C. So the case where the officers and different Congress people are suing Mr. Trump. We also have a response due in Florida, although I think they may have already done all of their responses. And then we've got Wednesday open, and then the 14th we have Florida hearing. So this is kind of the big hearing everybody's been asking me about. This is a non-evidentiary hearing, and that's what we're going to talk about tonight, what's going to be covered during that hearing. We also have any Rule 12 motions for the defense in Florida are also due then on the 14th. And then the 15th is going to be busy. We've got the Georgia decision coming regarding Fani Willis. We've got the New York criminal case. All the rest of the evidence has to be given to the defendant or the exhibits. For some reason, I feel like they probably already have them at this point, but the deadline is due there on the 15th. We have any opposition to the amicus briefs that are being accepted in the Florida case are due on the 15th. So that's what's going on there. Yes, we're the printer fund. Oh my goodness. True story, true story. Oh my gosh. So that's what this week is looking like, everybody. Now into next week, things are going to start to pick up. Of course, we are in the trial zone, everyone, which means we are just outside of that New York criminal trial that will be coming up very soon. So we have a few things to set us up for the New York criminal case. We have the immunity SCOTUS brief due on the 19th. We also have some response briefs for the Carroll case and, the last day in order to post the appeal bond in the New York fraud case is the 24th. So, and then before we know it, we've got voir dire starting, jury selection starting on the 25th. Rule 12 motions are pretty much any kind of pretrial motions. So I'm really not sure at this point what they're going to file. I was kind of looking at that as well. And, if he's got any kind of self-defense motions, he could file those, but I'm not sure what he would do for that. I don't know. Some of the things that they've listed: improper venue, pre-indictment, lack of specificity, improper joinder, suppression of evidence. Like, they're pleading all of these things already. Failure to state offense, discovery under Rule 16, which they've already done a motion to compel. So I can't imagine what's left, really. Not much is left. And by the way, I'm just looking here at the Federal Rules of Criminal Procedure when we're talking about the Rule 12 motions. So all of our motions and procedures are governed by the rules of procedure, depending on which jurisdiction you're in. This is the federal court, so that's why we're in federal court with our rules. So you think they've already played all the possible cards they might? Well, we'll see. We'll see. We've got a lot on the table right now. We've got, right now we've got a handful of motions to dismiss already from Mr. Trump that really are almost exactly the same as the ones for his DC case, with regards to immunity and various things. And then Nada has pled his, and De Oliveira has also pled his. We've got, maybe 12 different motions to dismiss. So that's all on the table. What's really, and I hesitate only because the motions to suppress in this case are really being handled in an odd way. And they're not being cleanly set on the docket. Now, Judge Cannon is being a little bit different about how she's wanting things on the docket anyway, but it looks like a couple of motions to suppress have been filed, but not specifically. So there's some questions with that. So that's why I hesitate. I would say they would want to do some motions to suppress straight up, but then technically they may have already pled them. I just can't figure it out because of how Judge Cannon is having everybody plead. So she set out in her docket how she wanted people to set their motions into order, and it's set out here in her order. Her order 320, it's a paperless order, and so it's kind of weird because there's kind of this, she wants them to notify her and the other side before they file it publicly, and then file it publicly. And so there's kind of this extra couple of steps that she has in here that really I've not seen before, so I'm not exactly sure. The government seems to kind of be trying to step around, and it looks like the defense counsel was saying, we don't even have to file any more Rule 12 motions. And she's like, you do. So there's a lot of confusion going on with that. She does use a lot of paperless orders. Yeah, so that's why I hesitate. I would say I'm still waiting, honestly, for a full fleshed out motion to suppress from Mr. Trump. I have not seen that yet. I've seen it being kind of kicked around here and there, but it is weird, Tiffany. Oh, I tell you, I've never seen anything like this before, where a judge is like, usually if you have a motion, you file it right on the docket. If there's redactions or sealings that need to be done, you take care of it. Even, in a SIPA case like this, you still, you take care of it, you file it cautiously. But here, this idea of it going to chambers and then going to defense counsel and then filing it, so like there's 3 different copies, it's just really weird. It's an odd situation. It's ridiculous. Yeah. Well, and again, when we use that term bias, it has a lot of different meanings. And for me, I look at it from the kind of ethical point of view. I'm not sure she rises to the level that would be something that would disqualify her, but it's weird. Whatever it is she's doing is weird, okay? Straight up, it's weird. It's a weird thing, and I'm wondering if she's trying to do something creative because she's a new judge. Again, she's trying to be like, well, this is what I need to do in order to work this case. And, it's her court, it's her courtroom, so she can make her requests however she wants to take it. A lot of judges will actually put up online how they want their pleadings sent. What procedures they want to have done. They'll just set it out. If you're going to send pleadings to me, this is what you need to do. This is how you need to do it. And so, once a judge has been there for a while, you just get used to their style. So for her, she's setting it up. It's just kind of an odd way of setting it. But again, this is her show. She can do that to a degree. It is her court. It is absolutely. But you also have to stay within the rules. So we do have to make sure that we're watching out for that. Your normal attorney and having to deal with Canada's bizarre. No, it's frustrating. And you can see it in Jack's filings. You can see how he's like, well, and this filing's for you, and this filing's for you, and this filing's for the public, and I guess we'll just file this one with the public too. Like he's filing all these different things, and he's like, I think this is right. If it's not, I'll file more or less. Let me know. It's very interesting. He's trying to be accommodating, so he's just filing all over the place. Everything's getting filed all over the place, and I'm just like, mad respect for that. Like, go, Jack, go. When can he go to the 11th Circuit? So he's got to have an appealable issue, and that'll be up to him. What he thinks is a proper appealable issue, then at that point he can try to go that route of interlocutory appeal. Again, an interlocutory appeal means we're appealing before the case is done. Typically, our appeals happen after the case is finished when we have a verdict. But there are some very rare special circumstances where an interlocutory appeal is allowed. And so if he finds there's a special circumstance, then perhaps he will take that route. But it will take quite a bit. Delay the flow of documents, perhaps. Anytime you have to do any kind of special procedures, it's going to change things up. But again, judges are kind of weird. Sometimes they have certain quirks and certain ways that they like to have stuff filed. And I guess she's got some kind of a quirk that she's doing here. Probably getting close to appealing. Yeah, I would say the one person in the U.S. who is acutely aware of appealing to the 11th Circuit is probably Jack. He's probably got that like on his to-do list, like, okay, but you got to have everything in place. What you don't want to do is appeal and get knocked down by saying, you have no basis for an appeal. So if he's going to appeal, he's going to want to definitely have strong, good grounds to go up on an appeal in order to make it worth everybody's time and to pause everything while it's appealing as well. So he's got to be really, really for sure that this is the route he wants to take. So, as opposed to at the end, whenever you get a verdict in, you're like, I'm appealing. Everybody appeals all the time. Fine, go for it. But if it's in the middle of a case, you better really be sure that you've got strong grounds. So how many people are working with her for Jack Smith? Now that I don't know, but if you want to look it up, you can. You can pull up the docket, which is actually what I'm looking at here. I'll show you what the first page looks like. here, and the docket can be set out in several different places. But if you pull this up, what it will show you, it'll show you the entire road that this has been down. I only have February and March here for purposes of tonight. But if you take a look, you can see the attorneys that are filing everything. So the attorneys filing for Jack, the attorneys filing for Mr. Trump, who exactly is filing for Ms. Cannon or Judge Cannon as well. So all of that is set in the docket, and every single document is giving credit to whomever filed it. So means others to file in a certain way to facilitate record clarity and schedule. Yeah, that's different, isn't it? Record clarity. I'm like, oh, well, I don't know. And and I'll take you through the docket just to explain kind of what's been going on in these last couple of days, or a couple of weeks, but it's kind of messy. It's because it's unclear, and the other attorneys here, the defense counsel, are even unclear as well. So unclear. And would that include the lawyers just doing research? So anyone who is an attorney of record, all right, so an attorney who is working on the case has to file with the court. So, for example, here, let me see if I can find this case. We've got motions for, let me see. Hold on. Let me just give you an example. Anytime new attorneys come in, even if they're not filing cases, but if they're starting to come in on the case, they do have to file. So I'm just looking real quick here. Here we go. Notice of attorney appearance. So just on the 6th here, there were two attorneys, or just one attorney, I guess. I thought it was two, but one attorney who's joining the team. So if you're appearing for the U.S. and you're an attorney that's on the record, you do file. Now, we may never see this attorney's name again, but they have to show that they are a part of this case if they're a licensed attorney. Now, if you've got paralegals and multiple other staffers and various other people working on the case, that's a different story. But if you are an attorney, a licensed attorney working on this case, you've got to have that in the record. They're pretty careful about that. Yeah, they have to be pretty careful. How often do you do your nails? Just whenever I feel like I want to do them. So helpful. I do try, Kyle. I do try. There's going to be lots of questions, of course, but are there rules? Yes, there are rules on paperless orders. I don't have that set of rules right now, but there are some rules that the federal courts have in general regarding filings with judges and so on. They do have some general rules. Again, I don't have them with me, but I do have them. Wish Alina Habba was on this case. Oh dear, no, we don't need that. Oh, no. Can we make Trump refund taxpayers for what he's cut? No, that's, although interesting question, but no. I'm afraid not. Given the history. Well, the thing is, she's one of about 10 judges. She's the least experienced of all of the judges that could have taken this case. She is the least seniority. She is absolutely the bottom of the seniority pillar, and she, her number came up for this one. So it's kind of a tough draw for her too. So the whole situation is kind of, yikes. It's questionable. So welcome in, everybody. Welcome in. Thank you for joining me. I will go ahead, I think, and get started tonight. I typically do my sub chat only on Sundays, but tonight I did want to open it up because I have been sick these last few days. We've got a lot of questions going on with the Florida case. Don't forget to check the screen. Yes, VC. Oh my gosh. So everybody, I've been having some troubles recently with my lives going dark, and I thought it was my battery, but it's actually, they're doing this new thing on the lives where you have to do a couple of checks, I guess, at some random point, and if you miss it, they'll shut your live down. So what I've done is I'm actually sitting on a really, really, really high stool so I can make sure I can see everything. So if I fall off of the stool, I've got to be at least 5 feet off the ground right now. So if you hear a thud, that's me falling off. No, no, no. I'll get it sorted out. But for tonight, it's working. Already asked and answered. If Cannon dismisses the case, what will Jack do next? Well, Paul, the question isn't what will Jack do next. The question would really be how is it even possible for Cannon to dismiss the case at this point? So we just do not have there. I mean, there's protocols, there's procedures that you have to go through. I mean, we can't just come in and she said, wow, great argument. Okay, case dismissed. Technically, I suppose she could, but also, we could set ourselves on fire, like, I mean, it's possible, but I could also possibly see a unicorn running around as well. So I'm just saying, highly, highly unlikely. We do have protocols we do have to follow here. Now, it's good to keep in mind, everybody, and I think it's important to keep in mind that there are multiple motions to dismiss that have been filed by Mr. Trump. He also filed a whole smattering of motions to dismiss in the DC case as well. So very, very similar. Oh, absolutely, Paul, absolutely. And he filed very similar cases or very similar motions there. Now, if you'll remember in the DC case, everybody, she took the immunity motion to dismiss based off of presidential immunity, and she ran with that because she said, Judge Chutkan said in DC, look, if this is a real legit question, we got to answer this before we move forward. So the other questions that he had for his motions to dismiss, those haven't even been answered yet. So those questions have not been answered in the DC case. So we are just kind of coming into that same situation here with the Florida case. Mr. Trump has filed multiple motions to dismiss. So let's take a look at that, and has asked for hearings on all of them. And we have one hearing coming up this week. So here we go. It's going to get, yeah, I know. Yeah. Yikes. Yikes. So let's just take a look at the big ones here. And these were filed February 22nd, and it's important because two of these are the ones that are going to be in front of Judge Cannon on Thursday. And also keep in mind that the hearing is not an evidentiary one. It's just for arguments where the attorneys are going to stand up and just kind of argue. So kind of like oral arguments in front of the Supreme Court. There won't be any evidence, any of those things done. They'll just be kind of arguing their legal perspectives. So we have first a motion to dismiss based off of presidential immunity. So that was his first motion to dismiss. That's not going to be answered this week. A motion to dismiss based off of unconstitutional vagueness. So this is one of the two motions that she has said we can argue about. And when I say argue, I mean literally an argument. How many people work in a judge's office? Oh, it depends. It varies. It could be 2 to 2 dozen. So it really depends on the jurisdiction. But definitely they're going to have some clerks helping them out. So this will be one of the big questions they have, whether or not the indictment was unconstitutionally vague. So that's the first one. Next, we have a motion to dismiss based off of the unlawful appointment and funding of special counsel Jack Smith. So this may remind you a little bit of what's going on in the Georgia case, because it's very similar to what's been going on in the Georgia case since the very beginning, where a lot of people have been saying, D.A. Willis didn't appropriately call in a special prosecutor. So this was being pled out months before any of the shenanigans went down. So very similar to that. Now, this one is not on the docket yet. Now, the second one that's on the docket is this one, a motion to dismiss based off of the Presidential Records Act here. And he has filed that. So this is the second motion. So these are the two motions that are set to be argued this week in front of Judge Cannon. So we do have responses from Jack on both of these, and I'll kind of take you through an overview of these motions. I'm not going to read through the motions. It's excruciating, so I cannot do it. It's too painful. But I will walk you through the motions and kind of explain what the big arguments are here so that you can see what the hearing is supposed to be about. So this is what we've got set then for the hearing. Yep. Yeah, so Yeah, and then we've got notice of pretrial motions and hearing requests also. So this is, I mean, again, we're struggling with exactly how they want to have things filed. Are we just filing motions with notices included, with requests for hearing included? Are we also filing notices? We have notice of a pretrial motion, a notice of a filing. So why are we filing a notice to say that we're going to file something? It's getting very odd, and it's because of this paperless order that Judge Cannon has. So this is what I'm talking about, that nobody really knows how they're supposed to be filing this stuff because she just set it out here in this paperless. So you're going to see a lot of that coming up. You're going to see, like, I think we're supposed to file a notice, but I'm not sure. Here's another notice. We have a reply and response, motion to leave or file discovery material, a paperless order here. Then we have another notice of filing. Then we have a response, and so on. So this is how the docket has really kind of stacked up, is this kind of problem that's happened here. Now, she did set out some minute entries regarding the hearings that they had, so they did actually all get together recently, but very brief. We had here, this is another thing where it looks like Jack kind of got into a bit of kerfuffle because he was struggling with exactly how to file everything. But we're back again. My page numbers are off a little bit, but his filing kind of was misfiled, so he had to refile it. But it just goes on and on and on, everybody. So we're in this situation now where we have a hearing that has been set by the judge. And so that much we do know. We do have replies by Jack, and then responses to the motions that Jack has replied to are due at 8 o'clock the morning of the hearing. So let's take a look at that before I walk you through the motions. If she dismisses these motions, what recourse is there? So, right, so if she dismisses the motions, then there's two more motions that'll have to be argued for Mr. Trump, and then there's motions argued for Nada as well as De Oliveira. They all have motions as well. So then all of those motions would get set for briefing and hearing and so on. That's kind of how that goes. That's this week. That's right. That's this week. So let me go through and explain exactly what the hearing is that is this week. So we've got a notice of a non-evidentiary hearing. So we have no witnesses being called in, no evidence being presented here. On defendant Trump's motion to dismiss counts 1 through 32 on unconstitutional vagueness. So that's document 325, which I just showed you, and defendant Trump and Nada's motion to dismiss the indictment based on presidential records, which is 327 and 331. So those two motions to dismiss are what she's addressing. The motion hearing set for the 14th at 10 a.m. here before Cannon. Counsel should reserve a full day for argument. The reply deadline associated with these motions is reset to March 14th. And of course, every motion and every response has a particular date set out in the rules. But she's saying here, I'm going to reset that to 8 a.m. and then we will come into the hearing at 10 a.m. So in order to accommodate the hearing. So this is what we're talking about here. So this motion for 331 is the question where I think we've got some kind of a suppression question, but I'm not really sure. It's not been docketed. So I don't know exactly what that is. So yeah, she's just not specified what it is. And it's also not in any of the court filings, which is a bit troublesome. So I'm not sure why exactly she has set that one out when we don't have a document for it. So just to give you some idea, that's what I'm grabbing here. So these are all of the filings, every single filing that is available to the public. Here I have pulled in red and gone through. And so I'm not just saying like, oh, well, I wonder where that went. No, like it's gone. There is none. There is no 330 Yikes, 331. Yeah, so it's an odd situation. And if we go back and look just through the docket, even if we're just looking at the numbers again, through the docket, we go through here and back 367, 348, even back here. Again, these are in an order just for me, so that's why they look like they're a little bit out of order. It's my own order. So there's 338 there. So see, we've got a filing from the government supplemental response to standing discovery order, which is 330, and then we have a paperless order on 332. So I don't know. There's been some kind of talk here where Jack has said in one of his motions the undocketed suppression question from Mr. Trump. So that's my question when it came to those Rule 12 motions was I think there is an undocketed request for a motion to suppress that's somehow included here. No, yeah, no, it's not. It's just not. It's not docketed. It's just not on the docket. It's not been filed on the public docket. So let me just get this back into an order that makes sense for other people besides just myself here. Yeah, so that again is what we're talking about. So that's where I'm not completely sure. I'm wondering if this will become clear eventually. Yeah, it's just, I'm just not 100%. I'm still waiting to figure out exactly what it is. The fact that Jack even mentioned it in one of his filings is really interesting. So, because he's like, hey, even the undocketed one. So let me show you what I mean. Let me show you the order I'm talking about, or the motion, just to kind of clarify here. So we do have, again, this is the one that I read last night, kind of did a bonus live last night. Won't get tried before the election. Yeah, I don't know if they'll be tried before the election or not. I really don't know. That for me is not one of my priorities. So I really, I can't say, I have no thoughts one way or the other for or against that happening, I guess. But as far as setting this out goes, she's looking at this point at August or September right now is what her schedule's looking like. So it's still possible. Yes, New York goes in 2 weeks. So it's still very possible that could happen. So vindictive prosecution, pre-indictment, grand jury, vagueness, motion to suppress. Yeah, so this motion to suppress evidence and dismiss indictment, this is what I'm talking about. This is the piece here that I think is that piece that has not been fully fleshed out. But we'll find out. We'll find out soon enough. Depending on requests from both parties, yes. Because Jack has said, we're not ready to go right now either, but we could go in July. So he has set that out. Yes, so the 25th is when the New York case is set for voir dire. So we do have a couple of pieces still going in New York of things that do need to be done. This is the New York trial calendar, everybody, just to give you an idea. This is just New York that we're looking at here. We do have a few things going on, voir dire starting here. We had a few other things, including the motions in limines going on. Orders regarding the jurors' names have happened. So we still have a couple things for this week as well. But this is the trial calendar for New York. Yep. Got it. Yeah, it is. Won't be televised. Yeah, no, it's not going to be televised is my understanding. I think it could be, but so far I've not heard anything about it being televised. But I think there will be people in the room, though. I think there will be people sitting in the room taking us through it. step by step. So there will be that as well. So I think that's important. We'll have that. August date is getting close. Yep, it certainly is. Yeah, I have no clue. And at this point, once we had once the DC case went off the docket, then there's no way to know what federal case is going to go. Technically, if we go in the order in which they were filed, the Florida case was filed before the DC case. So it went New York, Florida, DC, and Georgia. So if we were to go in the same order for trials, we'd have New York, Florida, Georgia, or DC, and then Georgia. So that would be the same order if we went in the order of the indictments, but we don't know what's going to happen at this point. We just don't know. Only on the two motions. Right, only on the two motions. You got it, James. Yep, she's only going to hear arguments. It's not an evidentiary hearing, and that's huge, everybody. An evidentiary hearing means she's going to be the fact finder at some level. And which is always, you never know what's going to happen when that happens. But if she's just listening to arguments, she's listening to persuasive arguments, and people are coming in and giving their sides of what they think is the best thing. And then, she'll make a decision. But it'll take her some time to decide that decision if she gives us a written order. Now, everybody, let me just pause for a moment and say, if this judge, I'm trying to be as positive as possible with this judge, if this judge comes out after this hearing with a paperless order or a minute entry discussing a very brief overview of the hearing, I'm going to have some questions. I'm going to have some big questions. It's going to be time for questions. bigger questions. Yeah, that would be very frustrating. Oh my gosh. So the other thing to everybody is even if these went to trial, and so even if it went to trial in August or September and a jury came back with a verdict, I mean, there's still weeks involved. If the verdict was guilty, there's still weeks before we can do a sentencing too. I mean, this is a really, really long process. Every step of this process is incredibly long. And we have all of the appeals going on. So, even if he's found guilty in August and there's 3 weeks set out for the pre-sentence investigation and he decides to appeal it, then the question is, well, he was found guilty, but it's on appeal. So, he's not really guilty because he's appealing it. So, I mean, these questions can go on and on and on forever and ever and ever until the end of time. So, I mean, we're just plugging away here in the criminal justice system. But if you're waiting for an indictment, you got it. If you are waiting for a conviction, well, you're going to have to wait for that. But if you're waiting for a conviction and then to win the appeal, I mean, that's the next step. So it's like it's not going to end. And then we've got finally then the sentencing period of time. And then the sentencing can be appealed. And, I mean, it just keeps going. It goes on and on and on. Can her judge put the foot down on the motions? Well, yeah, she's the one that said to do it this way. They tried to consolidate the motions in the DC case because of Judge Chutkan, and she did a pretty good job of that, I thought. But the judge here is saying, this is how I want to do it. So she's basically like, for everything is getting 2-3 times the filings. 400,000 in England. Yes. Yep. Yeah. For the Steele dossier. So yeah, and that situation was like, whoa, that's uncomfortable for everybody. I do plan to read through that finding because I think it's really good. The court was like, you're out of your mind. In a British voice. You're out of your mind. So I thought that was really well done. She did a pretty good job. Sky isn't falling. No, we're no different now than we were yesterday. We're in the same place as we were before. No, we're all right. Why don't all cases last forever? The funny thing is, Andy, I think that's a great question, but they do. They do. When you have really high profile cases like this and you have somebody who can afford attorneys to appeal the cases, this is exactly what happens. It takes years for these cases to be finished up. I had a case on something that didn't even involve jail time. It was a ticket, and it was appealed and appealed and appealed, and it took 4 years for it to finally be done. One of the biggest questions that people get, that I get when it comes to capital punishment, is that they feel it's cheaper. It's cheaper. And to just, end it and be done and move on. If you're for or against capital punishment, that's up to you. But what I've always said is, if you look at how much it costs to appeal everything, it's not, it's an issue. So we appeal constantly, and if you've got a capital case, you're going to get appeals over and over and over again. It's going to take forever. So yeah, I mean, it really does. It's just part of the process. I think I saw another attorney say, this is really shining a light on how slow the process is. And it is, everybody. This process is super, super slow. Super slow. But the reason it's slow is because we have so many checks in place. The goal and the reason why it's slow is because we want every single defendant to have due process and have a chance every step along the way. And so when we're saying, hey, the system, doesn't work or it's backed up, it's like, that's because we're just super, super careful. Now, is it the best process? I don't know. I can't say, but I'm not sure what's better. But we just take a long time because we have a lot of questions. We have to ask a lot of questions. Everyone is innocent until proven guilty. Exactly. And because of that, it takes a long time because every question gets to be appealed. But we have rules in order to keep things going. The other thing, too, is that you have to be able to afford it, or you have to be able to represent yourself, which is why we have a lot of jailhouse attorneys. We have a lot of people who are getting law degrees in prison and going down that road so they can represent themselves, so they can file their own motions and work through their own appeals. So not everyone gets that privilege. It's true, Andy. If you cannot afford to go through the process, you will not be able to go through the process. I wish I could somehow candy coat it and say, oh, everyone's treated equally, everyone's treated fairly. But no, it's not. If you can't afford a good attorney or at least an adequate attorney after you've been found guilty, I mean, once you've been found guilty, you've got court-appointed counsel, you're done. But after that, if you can't afford to hire an attorney for your appellate work, I mean, you're doing it yourself. That's absolutely one of the things that separates people in our system. If you have the money to pay for it, great. If you don't, you're doing it yourself or you're done. So I think the light's really being shined here on Mr. Trump because he has the money. He has these attorneys who can keep filing all of these things and keep kind of pushing everything. And also his attorneys are in a situation where they're not getting knocked back immediately. Will they get knocked back later? Probably. But right now they're not getting knocked down. So they're going to keep running with it. It's not truly a fair trial. Well, now the trial itself, I can't say whether it's fair or not. But the appellate process after, when you have a finding of guilty or the procedural issues to go through, that's a different story. That's a different story, in my opinion. Why do some have to appeal from prison? Because they can't pay to stay out. They can't if it's not allowed by the judge. If the judge won't let you stay out, you're not going to be able to stay out. So yeah, I mean it's awful. It's awful. But it's just part of the system. It's better than it used to be. So I look at it that way. But it is very difficult. When you're found guilty, you're sentenced. The judge doesn't wait for an appeal. True. That's true. The judge does not wait for an appeal. You go in. You're in prison while you're waiting, typically, unless you can try to figure out a way around it somehow. So, sometimes judges have given people 6 months to a year before they have to report to the prison. So not only then, I'm holding my cup of tea, everyone, that's why my hands aren't here. But not only then did we go through the pre-sentence investigation and we went through the judge finally, deciding to incarcerate someone. And then the judge is like, all right, but you can have a year, you can have, whatever, before you actually have to show up to prison. So there's all kinds of ways that those can be worked around as well. Yeah, find more money. Yeah, and I'm not trying to say the system's corrupted, everybody, but there is a two-tiered justice system. And the two tiers are people that have a lot of money and people that do not have a lot of money. It's that is how it works. It just is. You can find a lot of resources and you can find a lot of people helping out there, but if you don't have the money to go through the process or to understand the process, you're not going to be in the same position as somebody who does have the money. That's, the reality of it, unfortunately. Which is one of the reasons why I try to come on as much as I possibly can for free, for free, and explain how things work for everyone. For everybody to have that equal opportunity access to this information. I think that's so incredibly important. So, but yes, I can understand. I'm not going to be on here and say, hey, everyone's treated equally when it comes to the haves and the have-nots. I think as someone says that, yeah, no, it's just not how it works, unfortunately. So, all right. Oh, thank you. Thank you. All right, everyone. So with that, did I cheer everybody up? I cheered everybody up with that. Yikes. Yeah, I mean, it's true. It's true, Lisa. I wish volunteer legal services are so important. Absolutely, Tiffany. And pro bono work is incredibly important, and even support for pro bono work. For anyone that can offer, help for people who are offering pro bono, that's incredibly important. So very important, very important. And it's so much better than it used to be, and it gets better every year. I think our numbers of attorneys in my state that are doing free or donated legal services every year increase. It increases every single year. So more and more and more, and we try to do our best. Use my mind. Oh, of course, Olga. We'll be all right. We'll be all right. So, all right, let's start diving through. Let me just explain to you what a couple of these motions are before I dive in and explain the motions that will be in front of the judge. Wants to do his website. No, I've not. I've heard that. Are you talking about the Agenda 47 stuff? Yikes. That stuff's like, ugh. So we have a government's second motion for certain redactions and sealing. So the government filed, I don't know, about a dozen different motions, put in the hot seat. Absolutely, Mads, and rightfully so. And quite frankly, it's about time. I'm very thankful for that. I think that it should be. Anyway, they filed about a dozen motions, and so this is one of them. So the government's saying, again, we want to have certain redactions and sealings done on some of the information that we are putting out here because we don't want the information on personal information to be made public. So he filed another motion just to say, hey, yet again, the redactions and the sealings when it comes to what was involved with the warrants, we need to make sure that that's protected and is safe. So we also he went into the grand jury transcripts as well. So this is something that has been, also has been really discussed quite a bit. So he filed another one just to remind everybody. And then we start getting into his responses. And when I say him, I mean the team, everybody. So, of course, he's got a team working with him. So he filed a response to every single motion to dismiss that President Trump had filed. I call it President Trump because he files it as President Trump. So the defendant filed multiple motions to dismiss. This is the one on the Presidential Records Act. So I will take you through what Jack has to say about that. And that goes along with this one. This is the motion to dismiss that Trump filed. Again, see, note, it's President Trump. on the Presidential Records Act. So this is his motion to dismiss and how he decided to set out his argument. So we'll walk through that. Yikes. It's a yikes, everybody. I can no longer read through his motions on lives anymore. I can't do it. But anyway, and then we have Jack's response. So I'll go into that. Oh my gosh. Oh, it's awful. Oh, Heather, it's awful. Next, we have Jack's response to the unconstitutional vagueness question. So the defendant is saying, hey, it's too vague. You can't charge me with that. So he filed, of course, then on the 22nd, his motion to dismiss due to unconstitutional vagueness. And this is one of the worst motions I've read. And that's saying a lot because I've read a lot of really bad motions. Yeah, it's a lot of really bad motions, but this one's pretty bad. This one really doesn't have much legal basis on there. Oh my gosh. Yeah, there's not much for that. So also we have another one on presidential immunity. Again, Judge Cannon is not hearing that one this week. Every new motion it reaches a new level, I feel like they're challenging themselves to be even worse. I can't. I'm so tired of this, Grandpa. I've been saying that for days. And I have a little voice in my house that's like, this is too damn bad. That's been happening a lot in my house. Oh my gosh. All right. We've got another motion to dismiss based off of vindictive prosecution. We had a few hints at this one earlier. And we also, of course, had the same kind of question in the DC case as well. So next, we've got the response to the motion to dismiss for special counsel funding. So Jack was like, oh my gosh. Jack was like, excuse me? I'm sorry, what? This is how the special counsel works. And no. So that was set out. We also have this, again, I'm just kind of going through the motions he filed. This was all on the 7th, everybody. All on the 7th. So we've got the government supplemental response to a standing discovery order. Oh my gosh. These are all of the documents here that they're talking about that he's supplementing. And also the pleading complies with Local Rule 8810. So we're dealing with this kind of issue on what exactly is Judge Cannon wanting for her pleadings. It's kind of a mess. So he's filed that. We have another one, another supplemental response here. Or was that the same one? Nope, it's a different one. That's a different one. Let's make sure I get this right. 371, so a supplemental response. And this is 362, another supplemental response to the standing discovery order. 363 here, a motion for leave to follow filing procedures set forth in ECF number 320. So this was a filing by the judge by the government where he said, I'm trying to follow what you told us to do in your paperless order that you put on the docket. So is that okay? Oh my gosh, it made me so funny. It just made me laugh. It made me laugh. It was so funny. So he filed that in here, and he's got this like little, this is my favorite part of it. All right, so let's look at this footnote. So he's filing this, and he's saying, I would like to comply with the order that you set out in your paperless order. This should have probably been a regular written order. But I just want you to know, at the very beginning of this, you'll see that it's the government's motion, all right? But he talked to the other side and he asked the other side, he's like, hey, I'm filing this motion. And the other side said, hey, can you include a couple of things? I'm like, what? What just happened here? All right, so here's what they asked. So the government has met and conferred with defense counsel concerning this motion. Defense counsel do not object to the government following the procedures set forth in your order for the submission of the 4 briefs and attachments containing information for which the government will be seeking redactions or sealings. So, again, that's so funny. Counsel for defendant Nada requested that the government communicate his belief that at the March 1st, 2024 hearing, the court orally stayed all briefing on Rule 12 motions until the court had resolved all issues surrounding the redaction and sealing of discovery materials. Next, counsel for defendants Trump and De Oliveira believed that the court statements on that subject were ambiguous. Although it has yet to receive a transcript of the hearing, the government does not believe the court orally stayed further briefing on the Rule 12 motions and notes there is no memorialization of such a ruling in the minute order the court issued after the hearing. And then he's citing the docket number here of 361. The government intends to file its opposition briefs on March 7th. Counsel for defendant Nauta requests clarification through Jack's motion. This is the government's motion. And so counsel for the defendant Nauta is requesting clarification as to whether the briefing is in fact stayed such that the government's filing of the March 7th would not trigger the 7-day reply period under the local rules. Oh my gosh. So he put in a footnote. He talked to the other guys, and the other guys were like, wait a minute, I thought we weren't filing any more briefs. And the other one's like, wait, yeah, it's ambiguous. And they're like, can you get her to clarify that? Oh my gosh. And so he put it into a footnote. Oh my goodness gracious. Oh, it cracks me up, everyone. It cracks me up. So you may not think it's that funny, but when you're dealing with this kind of situation, it's this far out of control, it's funny. So that takes me then to her order that she put out as well. So let's take a look at that. Let's take a look at her response. Just a second here. Let me get it. Apparently I have everything out of order. Okay, so here's her response, everyone. All right. What's funny is that they should be filing their own motions. If they don't understand what she's asking them to do, they should be filing a motion for clarification, or motion for written order on how you want us to file stuff. So here's what she wrote then in response. Paperless order granting special counsel's motion for leave to follow filing procedures. So she's giving him permission to file the procedures she set out. As a point of clarity, following the March 1st, 2024 hearing, briefing on defendant's Rule 12 motion is not stayed. Defendant's replies in support shall be filed on or before March 14th. Using the same procedures. So she had to come back in and clarify for the defendants. The defendants are confused too, everybody. Oh my gosh. Yeah, it shouldn't be in the motion. I agree. Like that really is something else. So I think that's really funny. Yeah, I don't know. I find it funny, and I think you have to find humor where you can. All right, everyone. So let's start taking a look at these motions then. Oh my gosh. Yeah, so Cannon even the defendants are like, wait a minute, what'd she say? Wait, Jack, what's going on? And Jack's like, oh, fine. Oh my gosh. Yeah, there's that. There's that. Yeah, I know, right? I know. All right, so let's take a look at these. All right, so we need to do the defendant's motion first because he's the moving party. So here's his, oh my gosh, this is a lot. It's a lot. This is a lot. So I'm just going to take you through an overview. I'm not going to read it. How did Cannon become a lawyer, let alone a judge? Well, I mean, she's just a baby judge. She's just a brand new baby judge that does not know. I mean, she just doesn't have the level of experience in order to figure these things out at this point, in my humble opinion. All right, so here we go. Here's the motion. This was filed on the 22nd. Motion to dismiss for unconstitutional vagueness. So what was set out here, again, I'm just going to kind of run you through it. We have applicable law for the vagueness doctrine. This is for Mr. Trump. That's why this is orange. If this is orange, it's a Trump document. Next, we have section 793C, which is the one of the code sections that he's charged under. Discussion, the authorization clause, unauthorized possession, the NDI clause relating to the national defense, the entitlement clause entitled to receive, the willfully mens rea element cannot save counts 1 through 32. Mens rea means criminal intent. Count 19 must be dismissed because President Trump maintained the required security clearance. And then the conclusion. So this is a lot. Again, this is Mr. Trump's perspective on this. So again, I'll just run you through the highlights. I can't, it really does. Yes, I'm a visual person. So, all right, here's the introduction. He's basically saying that the section of the code, 793E, is unconstitutionally vague as it applies to Trump, a former president operating within the framework of the Presidential Records Act, which is the next motion. So he's saying it's too vague. This is very similar for those of you paying attention or watching in the Georgia case where we had all of those motions for demurs or motions to quash. Who remembers that back in the RICO case where the attorneys came in and said the original statute is unconstitutional and we want to bring in the original legislators that wrote the law and explain to you what the intent was and why the law itself is unconstitutional. Anyone remember that? Yeah, this is that motion. This is the Florida view. This is the Florida shot at that. The language is just, instead, the language is slightly different. It's too vague. The statute is too vague. So the law is written too vaguely. We cannot remember them all, even against our will. Isn't it true, Navy? So here we go. Judicial efforts, this is one of my favorite lines, judicial efforts to save this section of the code by attaching broad interpretations to a criminal statute in order to reach the conduct of defendants hauled into court by overzealous and politically motivated prosecutors is contrary to the rule of lenity. So he's saying, judges have been interpreting this rule wrong. So not only is the statute wrong, but all of the judges using the statute are also wrong. So that's how that goes. Related with all these Trump documents. Well, it seems like it, but all right. So we go through here, and again, let me hit the highlights for you. So his discussion, he's going into the vagueness doctrine. We do have a doctrine that says if the law is too vague or if it's overbroad, you can't use it. And he's citing some case law here. Now, with him and with his filings, I've not had a chance to cross-check these sites, so I don't know if they're correct or not. At this point, I've lost some trust, unfortunately. I've lost some trust in Mr. Trump's filings because they've been wrong. So next, we have the relevant portions. So they're going through this particular section of the code. This is the code section 793E. And he's saying these phrases, these words are too vague. So what the phrase unauthorized possession, it's too vague. Relating to the national defense, too vague. Entitled to receive it is also too vague. So because that language is overly vague in how Congress wrote it, then the statute is invalid. Now, an interesting point here that I think is worth noting is that a lot of his argument is based off of this law review article that was written in 1973. Now, there's a lot of things that have happened since 1973, but he's really relying heavily on this. So rather than, and I kind of went through everybody, I got to a point where I had to get the red pen out. I got to a point where I was just really correcting this like I would a student paper because there were problems. There were statements being made without any support, without any kind of support for appropriate citations. Yeah, like Watergate, exactly. So a law review article is certainly not going to weigh the same as a case. And his previous page, he said that the courts just weren't interpreting it correctly. And that's all according to this law review article, which is, just some dude who wrote a law review article. So he cites this repeatedly. So that's not particularly persuasive. And then he's citing other cases saying it's too opaque or it's scattergum. Like, what? And then he cites to the Defense Secret Acts, which apparently was the progenitor of the case. So, again, I'm just hitting the highlights here. Next, he goes into the Espionage Act of 1917, and he said the intent of the 1917 Act is different than what the intent is of what you're doing with the Act today. And then he goes in, repeats repeatedly over and over again this law review article. Maybe AI wrote it. I don't know. Perhaps. So I didn't do this on a live because I didn't want to get angry in front of everybody. Oh my gosh. Next, we have the Espionage of 1950. So at least he's recognizing that he's being charged with an Espionage Act. At least there's that recognition. So I think that's good. So he's citing these here. There's nothing to support it other than this law review article, which isn't really that compelling. Next is the discussion. So he's saying this section of the law is unconstitutionally vague as it's applied to the defendant. That's a great starting statement. But we need to see some support for it. So the question then would be how? How is it? How is it that it's unconstitutionally vague? Again, not as it's applied in general, but just as it's applied to President Trump, which is not legal standard, which I think is very interesting. So vagueness challenges must be evaluated in the light of the facts of the case at hand, which is true. But then we have, again, this law review article. So, again, I'm like, well, is all of this coming from this law review article from 1973? Is that where all of his support is? Sorry, I need a cup of tea. Just a moment, everybody. All right, so here we go. Then he's got a few citations. So he's citing the DiPetro case, the Gruen case, which the government also cites. That's a pivotal case. Davis, and Reese. Each one of these is just a quote from the case. There's no tying this in to like his case. He's just quoting. So, in college, when your professor's like, don't just use a quote and then move on, like that's what's happening here. It's just a quote and then they're moving on. Next, we have all of this. All of this is quotes. And then the only thing that's original is this sentence, because that is what Congress has done with Section 793E 3 times. And because the judicial efforts to keep the statute on the books are inconsistent with the Supreme Court's vagueness reasoning in Davis, DiMaia, and Johnson. And Johnson's not even cited here, like where'd you even get Johnson from? The court should reject these authorities and find the statute void for vagueness under the circumstances of this case, which again doesn't make any sense. I went to college. Well, yeah, you don't have to go to college. It's just one of those things where you get docked points. It's a point deduction. So these are the questions I would ask at the end of his discussion here. How did they do it? What are the examples? And applying the actual cases to the actual facts here. None of those have been done. So this, in my opinion, is just like, I'm not sure. That would be a loss of points. And then we just move on to subsection A. Like, that's it. It's over. We're done with it. All right, so next we have the authorization clause, unauthorized possession. Again, major questions. I'm looking at this like I would if I was doing legal research and writing. So that's why I'm making the comments that I'm making here, because I had to, for my own sanity, I had to go at it from that route. From a student, I'm trying to encourage to do better. Oh my gosh. So how and is it even required? So the authorization clause is unconstitutionally vague as applied to President Trump. How? because the pertinent language fails to provide guidance regarding its scope and permits arbitrary enforcement. So that, again, is so vague. That particular response is very vague as well. Screams ex-English teacher, yes, oh my gosh, look away, save yourself. All right, so he's citing this dairy production case. Here, there's far too much indeterminacy around the meaning of unauthorized possession. So this is his argument. He's saying there's too much indeterminacy. So therefore, because of that, according to whomever wrote this, not according to any kind of source or any kind of example, and that's what I'm writing here. I'm like, hey, where's your example of that? Where's your source? Where's your indeterminacy being determined? Who's deciding that? And we just don't have any support for it here. He goes in and gives a random quote from a random case I didn't have time to look up, so I'm not sure if it's correct or not. And then next he comes in and says, the documents that are the focus of counts 1 through 32 are only allegedly classified because of President Trump's original classification authority, which is a power derived from Article 2 of the Constitution, wielded pursuant to the people's mandate in 2016 and delegated as President Trump saw fit for the use pursuant to the Executive Order 1352-6. And then my question is, well, how's that? I mean, how is this? So the only thing that makes sense for this sentence is this is what the attorney thinks. And I'm like, hey, that's great. Good for you sitting there at your desk writing this sentence, but there's no support for it. There is absolutely no support. He just says that, and then all of a sudden we're doing a quote here. He's quoting a concurring opinion. If the Constitution gives the executive a large degree of unshared power in the conduct of foreign affairs and the maintenance of our national defense, then under the Constitution, the executive must have the largely unshared duty to determine and preserve the degree of internal security necessary to exercise the powers successfully. Like, that doesn't make sense at all. That doesn't make sense at all. And it doesn't tie in either with what he's saying. If you see a 401 over here, that's the rule for relevance. This is the rules of evidence, so it means it's irrelevant. I find that what he's saying is irrelevant. So there's problems, everybody. And then he's citing the Hur report, right? So this is the report written about President Biden. It doesn't, Jess. How does it apply? It doesn't. It's not. It doesn't. I cannot. Like, I have to be careful that I don't hurt my own brain trying to figure out how this is an appropriate legal argument. So I do have to be careful. I have to walk carefully. So, but let's look at this quote here. 401, you bet, David. That's irrelevant. It's absolutely irrelevant. Here's a quote from the Hur. Okay, past presidents routinely took national security files. Hur report at 192. That's it. It's like 1, 2, 3, 4, 5, 6, 7. 7 words. And no one suggested that their possession and retention was unauthorized, as discussed in President Trump's motion relating to selective and vindictive prosecution. So why are we using 7 words out of the Hur report? Like, what's the purpose of that? I know. Had this many red marks. Yeah, it's a... trying to not. All right. So here's a couple of questions I had. How is the Hur report relevant? You have to set a foundation if you're going to use another source. Random quotes need to be supported with context. And so that's what I would put if I was grading a paper. So, stupid. Oh, I don't think Miss Haba wrote this. I don't think so. A giant bologna sandwich. Oh my gosh, everybody. All right. So here's the next piece. Kind of hop into that. So we turn the page, and here's the Duren case. Here's a quote, And he's saying, so he's doing a couple of quotes, and then here's the statement. The non-criminal nature of the Presidential Records Act exclusive remedy for collecting presidential records added yet another layer of ambiguity for the application of a criminal statute's use of the term unauthorized to President Trump. So there's no support for this at all. There's just no support. I think this would be an interesting argument. I mean, he's not going to win it, but it'd be worth his time to actually flesh this argument out, to actually make this argument. But he's not even making the argument. How is it ambiguous? Is it because of only this case, or are there other criminal cases that make it ambiguous? So those are kind of big questions. Yes, exactly. All right, so the next piece we go here. Even if the authorization clause provided adequate guidance to President Trump, and it did not, the vagueness of the phrase unauthorized possession under these circumstances also gives rise to an impermissible risk of arbitrary enforcement, which is reflected by the numerous examples of cases involving similar situations where prosecutors brought no charges, as discussed in President Trump's selective and vindictive prosecution motion. So this particular piece really bothers me. They're saying there's a whole bunch of examples. So this is where, when you go out and you make a bunch of claims in the media or online, or when you're outside of a courtroom, you can say all of this. You can just serve up this bologna sandwich and serve it up to all of the American people that you want. Just hand it out. Just hand it out for free at the door. But when you're in a courtroom, you have to support this stuff. And he's saying right here, I've got multiple examples where prosecutors brought no charges. And there's nothing to support that. The only support that he gives is to say, look at my selective and vindictive prosecution motion, which is the most insulting thing you can do to a judge. You're saying to the judge who's reading this, well, if you want to see examples, go look at my other motion that I filed. Like, are you kidding me? This is a legal writing 101. This is inappropriate. You do not cite another motion that you've already filed as support for your own vague statements of conclusions. This is real bad, everybody. It's pretty bad. It's exact. I know. So this is really bad. And this shows again the difference between how much, like you can lie all you want out to the American public. You can lie all you want. It's not illegal to lie, as Mr. Trump has proven time and time again. You can lie all you want, unless it's a financial statement. But when it comes to filing stuff here, you can lie, but if you lie, you better support your lie, because without that, you're going to get called out. So this is awful. This is pretty awful. Yeah, it's pretty awful. So there's a whole bunch of examples where prosecutors have brought no charges, which is like, how do you have examples of no charges? First of all. Second of all, only because of your own selective vindictive prosecution motion, because you said so in a previous motion. So it's awful. It's pretty awful. Do they realize yes, they did. They did. It's a lot. I gotta have a sip of tea, everybody. I gotta drink some tea. I need a moment. I need a tea break. I need to collect my thoughts. Oh my gosh. It's bad. It's bad. Why does it say cleaned up? Probably because if this is a particular citation, so all they did was cite to the page it started on and the page that they're quoting. So there was probably a string of citations. There could have been some other italicized words here as well. So they just cut it short. It's just a way of abbreviating it. Yeah, it's tough. Yeah, he did respond. All right, so next we have the NDI clause relating to the national defense. Okay, we're going to kind of skip through this. We've got some cases, again, that I didn't have a chance to double check, so I don't know if they're valid or not. To recognize the difference between Trump. No, I don't think so. I think there's something wrong with them. I mean, I don't want to be rude about it, but after reading all of these motions, and I've read them all, everybody, I think there's just something that's not quite right. Yeah, I mean, truly, I think there's something that's missing. I'm not sure, like, did they test out? Did they test out of legal research and writing? And I'm not saying if you test out of something that you're not good at it. I'm just wondering if his attorneys, in this case in Florida, tested out of law school, back in the 30s or whatever it was, like, they may want to get something more up to date. And I don't want to be rude about it, but it's frustrating and it's hard to watch because this writing is inappropriate. All right, so we go on here. I've got more questions. This is one of the big cases that Jack is citing repeatedly here, and they are citing it incorrectly, so I'm not going to spend much time on that. And then I found it interesting that a couple of times they cite their cases here, but they're citing the opposite argument. Now, technically, it's great to pull in opposite arguments because it can help to persuade how your argument's better. So, like, these people lost on their argument, but their argument was weak. Ours is much stronger. Here's a quote, all right, of one of his that he's doing here. So he's saying in another case, which involved the same statute, the charge relating to information was relating to information rather than documents, that the court observed in dicta that the prosecutions under both the documents and information clauses, the government must show that the disclosed NDI relates to national defense, meaning that it's closely held and that its disclosure would be potentially damaging to the United States or might be useful to an enemy of the United States. So I'm not sure exactly how talking about this exchange of information is helping him. My point that I wrote out here was the case they're citing has to do with exchanging words. So they're like, hey, here's some secret information. Let me tell you about it in this case. But meanwhile, this case is literally about documents. So I would say this is almost an irrelevant citation. All right, so here we go. We'll kind of turbo through the rest of this so we can get to Jack's response. All right, so we're citing the Second Circuit, which is not the 11th. And every time I write this, it's to remind myself of why the Supreme Court took up the immunity question. So just doing that for myself. Next, they're saying Congress failed to address the vagueness concerns in connection with the Espionage Act of 1950. So because of that, he's saying then because they didn't address the vagueness issues of the act in 1950, which included some of this language here, then it's too vague. So that must also mean that it's too vague. All right. Next, nevertheless, based on Gorin's reasoning regarding different statutes, reported decisions outside the 11th Circuit have applied a judge-made requirement in a strained effort to save 793E from the fatal vagueness problems that it presents. This is another incredibly offensive way of writing this because he's saying a strained effort to save this section of the law. And judge-made requirement is precedent. So he's saying other judges have made this requirement in order to make the law work, which is, what judges do. They fit requirements and they do laws like, the Miranda warnings. That's judge-made. And this is frustrating to me because he's saying other judges, other precedent is bad and that should not be used. Because this is too vague and all the judges trying to get it sorted is not good enough. So it's frustrating. This particular piece is also frustrating. Also, we go here and he does put in a few other opposite arguments involving the government's argument. So I'm like, all right, do you want to help with that? And a few other things real quick. This kind of just abruptly ends. We don't have any more argument here. I kept waiting for the rest of the argument, but just ended just with the sentence. And I was waiting for that. So let's keep flipping through. And then we have whole pieces that just don't make any sense at all. So these two paragraphs have no sense at all. I don't get it. There's some like degrees of gloss involved and the gloss proposition in the Rosen case, but the Rosen case was based off of dicta, which isn't ruling. Dicta is just like the judge's thoughts. Now we have interpretive gloss. Oh my gosh, it gets to be a lot. So, and then specifically they quote a case that rejected that this was too vague. I'm like, okay, well, there you answered your own question. We don't have any relevance here. And then I'll skip through. I did want to show you again, he's citing that Law Review article from 1973 again here. And he makes a direct quote that he is saying, the executive order that sets out the classified documents here is another way of conferring unfettered and wholly subjective enforcement discretion to the executive branch. This is one of the principal evils that the vagueness doctrine was established to avoid. So, all right, so I'm not going to go into too much detail for the rest of this document because I need to take a minute. So this lawyer, everybody, let's just clarify. This lawyer here, he's saying that the rules regarding classified documents set out in the executive order gave unfettered power to the president. Unfettered power to the president. And I will have you note that in all of his other motions to dismiss, his argument is, I had unfettered power, and therefore you can't charge me because I changed everything from classified to not classified. So this argument, there's too much power given through the executive order, is the argument he's using to support all of the rest of his motions to dismiss. So that's that. I can't. So we'll just fast forward the rest here. All right. So count 19 and then we've got a conclusion. All right. So oh my gosh, everybody. All right. So that's the motion to dismiss for unconstitutional vagueness. Let's take a few minutes and go through Jack's response. Oh my gosh, I know it's painful. It's painful, everybody. It's painful. All right. So again, this is one of two of the motions that are set for the hearing this coming week. So when you're wondering like what's going on, this is because they're going to debate or they're just doing arguments. No evidence is being done. This is just arguments. So this is the government's point of view. All right, so first, a statute is not vague as applied when it gives the defendant fair notice and provides standards for the exercise of prosecutorial discretion. So I think that's important. Prosecutors have discretion to bring cases or not to bring cases. That doesn't mean that there is selective, vindictive prosecution. It just means they decide. They get to select which cases to bring and which ones not to bring. You have to have a kind of malicious intent in order for there to be this vindictive element. So that's really the piece that they're missing in their argument. Trump had fair notice that his conduct violated Section 793. So he was told, dude, give us our stuff. You have our stuff. You're not supposed to have our stuff. Courts have consistently upheld 793 against vagueness challenges. So all of the precedent says that the courts are fine with this section of the law. Unauthorized possession, they go into that. Relating to national defense, they go into that. Entitled to receive. Next, Trump was personally on notice that classified national defense information must be handled appropriately. So he knew classified national defense information needed special procedures. He knew that. He was aware of that. He was told that. There's no vagueness in that. Section 793's willful scienter requirement, that means intent. So you're willfully acting in a certain way with a certain type of intent. Requirement alleviates any possible vagueness as to the meaning of the statute's other terms. Next, Section 793 is neither standard lists nor encourages discriminatory enforcement. And last, Trump's challenge to count 19 lacks merit, which I think is genius. That's really all you need to say, is that it lacks merit, because it does. So we go through, and he sets out. It's the one thing I will say about Jack's filing is that it's very well organized. It's very well organized. It's like he just is setting it up and knocking it down, or whomever's writing this. Again, I'm assuming, I'm just using the name Jack Smith as the person. We don't know if he's the one that actually wrote it. So he's saying, he's summarizing Trump's entire argument right here. Trump relies on three factors in claiming that Section 793 is vague as it applies to him. All right. Number one, his former service as the president who acted as the ultimate original classification authority. Two, his recourse to executive privilege. And three, his asserted immunity for official acts. These assertions stem from Trump's pervasive claim that his former service as president somehow exempts him from the laws and principles of accountability that govern every other citizen. But none of the factors he identifies make Section 793 vague as applied in this case. The decisions that have actually interpreted Section 793 have rejected similar vagueness claims in case after case, and for good reason. Let me flip here to the next page. Trump's challenges is likewise unfounded. So he goes through and sets out how the precedent, so he actually uses the case law and says repeatedly, it's not vague. It's, this is the case law. So this is an actual legal argument that's set out. So let me just read through what Section 793E is, just to clarify. So it provides in relevant part that whoever having unauthorized possession of, access to, or control over any document, writing, code book, signal book, sketch, photographic, negative, blueprint, plan, map, model, instrument, appliance, or note relating to national defense and willfully retains the same and fails to deliver it to the officer or employee of the United States entitled to receive it is guilty of an offense. So that's what the code section is that they're saying is vague. So let me pause for a minute, everybody. For those that heard, does that sound vague to you? Let me just ask off the cuff here. For me as an attorney, I have my own thoughts, but does that seem vague? Is that a vague statute? Let's look at the language again. Whoever having unauthorized possession of, access to, or control over any document, writing, code book, signal book, sketch, photographic, negative, blueprint, plan, map, model, instrument, appliance, or note relating to the national defense. So that's one of his pieces, is he's saying unauthorized possession is too vague. National defense is too vague. Those terms, he is saying, are too vague. And what Jack goes on to argue here, and I can't go through all of it for tonight, but he's to say, you are president of the United States of America. Do you not know what unauthorized access is? First of all, do you not know? Another one, do you not know what military defense is? A couple of other phrases that came out later in his motion that I thought were really interesting. So well-established meaning here of unauthorized possession, also national defense, and what does entitled to receive it mean? That was his third piece. So he goes into the Gorin case. What was the one? I've got a great quote in here that just was absolutely fantastic. So he's saying again, Trump is saying the language in the executive order regarding this term on a need to know basis is ambiguous. Need to know is too ambiguous, and therefore, because that language is ambiguous, the statute involving anything using that kind of premise would be too ambiguous. Then Jack writes, but need to know is a principle applied with respect to all dissemination of classified information. And he's citing the executive order section. So he's saying, I don't understand what you mean by a need to know basis. And Jack is like, well, that's classified information. How do you not know that? You were president. Oh my goodness. All right. Here's the last piece I'll read to you here, everybody, and then I'll have to take a break for my poor voice. And it's defined in the executive order as a determination within the executive branch in accordance with the directives issued pursuant to this order, the executive order, that a prospective recipient requires access to specific classified information in order to perform or assist in a lawful and authorized governmental function as defined by the executive order. So the language itself is even specifically set out. So Jack did a pretty good job, everybody, or whomever wrote this, set it out very, very succinctly. We have every intent element here. It's not standardless. It's not vague. And we also have multiple pieces. Whoops, sorry, everybody. We also have multiple pieces where you should know this standard. So I will go through just this last conclusory piece here. Hold on, everybody. 1 minute. My light just went out. So just a second. At least it wasn't my battery this time, so that's good. But he ends on a really good note, I think. Or again, whomever wrote this, which I do not know if it was Jack or someone else. But at the very end, he writes, Trump offers no evidence that he was aware at any time of what the Department of Energy's internal records reflected regarding his Q clearance. So you may have heard of this idea like, oh, I already had clearance. I had this Q clearance, so I already had the proper amount of clearance. And thus those records could not bear on his state of mind. And what Jack puts in his final piece here is he's saying Trump didn't even know he had Q clearance. So it can't be used as part of his intent or his mens rea. Tough any consequences? Well, yeah, he did. He did. All right, everyone. I'd hoped to make it through both motions, but I'm afraid my voice is just about ready to leave me. So I will have to go ahead and take a break for tonight. But hopefully that's at least answered a few of the questions that people were having. Oh, thank you so much. We're having regarding the Florida case. I am hoping to come back on again as soon as I can and go through the second motion. I think we really have to spend some time on that presidential records motion. That's been his whole argument this whole time in Florida. He had authority under the Presidential Records Act. He sets out where he thinks he had the authority, and then Jack comes back and says, what are you talking about? So it's a very interesting read. I will take some time and go through that again. So I will need to just rest my voice, but I will be back again for sure. So keep in mind, everyone, tomorrow we do have a little bit of movement in the criminal New York case. We have quite a bit going on in Florida and then the Georgia decision on Friday. But I will be back as soon as possible, probably tomorrow morning, but for sure tomorrow evening, 7 o'clock Central. And I will be reading through the next set of motions here that I did not get to tonight. So have a wonderful night, everybody. Thank you all for coming and hanging out with me. Thank you to the moderators for working so hard. I truly, truly appreciate all of you. So thank you, Sue, so much. Thanks, Kyle. Appreciate that. And I will go rest my voice for now. So have a great night, everyone, and I will be back again very soon. So take care.